Good afternoon, everyone. My name is Maggie Curiel, and I'll be presenting the Code of Ethics portion of today's new member orientation. If everyone, or someone, not all of you, because there's a lot of you on here, but if someone could just chime in and let me know if you can hear me, just a
I can
yes or a
hear
no.
you.
Yay, perfect. All right, Connie confirmed.
I'm gonna walk away, Maggie, but I'll be right back, okay?
No worries, no worries. All right, I'm glad everyone can hear me, and everyone should see my presentation on screen. If you have any questions, I don't usually get to look at the chat while I'm presenting. I will try to kind of take a look during breaks, but my recommendation is if you have any questions, just kind of hold on to those and then maybe email professionalstandards@miamire.com. Again, I'll try my best to take a look at the chat whenever we take breaks, but I might miss your question in the process. And so if you have any
Maggie,
questions, yes.
we may have to interrupt you for a minute. Don Fallenbaum is gonna be joining us. He
Oh,
couldn't join
okay.
us at the very beginning. Would you mind?
Not at all. Not a
We're not sh
problem.
we're just not sure when he's going to join.
Okay, so whenever he does join, just kind of chime in and let me know, and we'll take the opportunity to let Don present and talk to the participants, and then we'll just continue as usual.
As always, you're the very, very best.
I mean, I wouldn't go that far, but
Well, I know
we
you, so I
we
can
work
say,
we work together. We work together. All right.
thank you.
All right. So for today, like I was saying, I might not be able to answer your questions in real time as you place those in the chat. But I'll try my best to take a look in between when we take breaks. We'll take like maybe two breaks today. And then worst case scenario, you can always email those questions in and we can try to answer. Um, Sometimes I might know the answer to things and I can't. So my general disclaimer is, or my banner, I should say, I should hold this up as a sign, is that I am not an attorney. I am not a broker and I am not a licensed real estate professional. So although I may have some understanding of some of the questions and some answers that I may know because I've seen it before, because I am none of those things, I cannot offer you those responses. Okay, so if I can't answer your question, I'm not trying to be purposely elusive. It's just I am not able to. Um, I cannot. And you do have resources available to you, like the Florida Realtors Legal Hotline, your own broker, or your own legal counsel. And if you don't have your own legal counsel, you can always use the Florida Bar referral system. All right. So, as mentioned, I'm Maggie Curiel. I am now the VP of Professional Standards and Broker Relations. Generally, I am at the global headquarters location where we have these really great state of the art hearing rooms and mediation rooms for professional standards proceedings. We do have a resources page. So if you visit miamirealtors.com/professional standards, we have some FAQs, we have some resources, and then we also have the manual link there. The manual comes from NER and it's the Code of Ethics and Arbitration Manual, and it guides the rules and procedures for all professional standards proceedings. And if you ever need us, as I mentioned, you can email us at professionalstandards@miamire.com. That goes to the whole department. We usually answer in 1 to 2 business days because we are also participating in proceedings and we're in and out of hearings and different things. So we might not get to the email right away, but we do generally answer within a day or two. We use an online system. So all of our cases are filed and managed through an online system called CasePro, and the emails are generated from that system to let parties know when there's a hearing or to let them know that we need them to upload something. That communication is meant to be one way, but I wanted to make sure that you did add it to your safe senders list so that if you ever are sent any communication from the system, you don't lose it, don't see it. We don't want it to end up in spam or junk. We want you to be able to be aware of what's going on. So we would recommend adding CasePro at miamire.com to your safe senders list. I would recommend professional standards too, because if I email you directly, it's usually going to come from that email address as well. All right. And then, by the way, I also do not work in isolation in that department. I do work with our two attorneys. So it's Evian White de Leon, who's chief legal counsel for the association, And then I also work with Elizabeth Soto, who is associate legal counsel for the association. We do have law clerks that work with the association, and they also help with different things like litigation searches and looking for records, stuff like that. So we do have some objectives today because this is a requirement for you from NER. You have to attend an orientation, which that's what you just did with Connie. And you have to take code of ethics, which is what you're going to be doing with me over the next 2.5 hours. So our objectives for today are to identify some concepts that are found in the preamble of NER's code of ethics. So before you even get to Article 1, there's a preamble and there's some ideas that are established in that preamble. And we'll just talk about that. I'll be talking about it in general as I go through. We'll talk about some ethics and compare and contrast the code of ethics. And we'll also talk about the concepts that are established in each of the articles and what possible violations look like. So there's a part of my presentation where we kind of go through hypothetical situations, and I'll ask you guys if you think it's a violation or not. Those come from the case interpretations provided by NER, and you can access those on their website, just like you can access the manual that I've mentioned, the code of ethics itself, the articles. You can find all of that on NER's website, which is ner.realtor. We're also going to talk about the professional standards process. So what does it look like when a complaint is filed? What does it look like when a request for arbitration is filed? What happens at a hearing? We'll talk about that entire process, and we'll talk about how that process is set up to ensure that everyone is afforded due process, that everyone gets the same rights, that everyone gets the same process. And by ensuring that there's like uniformity, everyone is afforded the same process, and there's no room for the process to, kind of not afford someone their chance to kind of speak their part. We'll talk about how you can use the code of ethics in your day to day. And then we'll talk about pathways to professionalism, which, sometimes people can be unprofessional, but not unethical. And so, although I wish we could find some way to enforce things when people are unprofessional or not behaving as they should, we are limited to only enforcing potential violations of the articles, right? So we'll go through that today. So a little bit about the history of the Code of Ethics and NER. So before 1900, there were no real estate licensing practices, and everyone quite literally did whatever they wanted. But in 1908, they established NER. So the National Association of Realtors was established in 1908. And by 1913, they had created their first version of the Code of Ethics. And I say the first version because obviously with time, things evolve and change. And the code of ethics is constantly being evaluated and it's constantly changing. Connie, I'm sure, mentioned to you guys what year Miami was established because I know that she likes to tell you guys. But does anyone remember what year she said Miami Association of Realtors was established? Ooh, 1920. You guys were quick. Great. You're absolutely right. It was in 1920. So not too long after NER was established, Miami Association of Realtors was established. So in 1989, what they started doing with the Code of Ethics is they started taking a look at the Code of Ethics on an annual basis to see if anything needed to be amended, deleted, updated, etc. Sometimes they're updating verbiage. Sometimes they're updating the concepts of an article. Sometimes they're adding new standards of practice. Standards of practice are like subpoints to the articles to help clarify what the articles mean. Sometimes nothing happens, right? So whenever there is a change, I do want to flag this, and I'll mention it again a few times, but they are going to establish those changes and they are going to basically vote on those changes to make them official, usually in October, November of every year. There's a big conference. And so once NAR has that conference and that's voted on, those changes then usually go into effect January 1st of the following year. So there are a couple of proposed changes that I've already heard of, and I will highlight those for you as we go through the articles. They're tied to Article 4. Those changes are going to go into effect January 1st, assuming that when they vote on them, they're accepted, right? But I just kind of want to flag it for you. My best practice, or my suggestion of a best practice, is that every January you log into NER's website and they usually have a document with a summary of anything that they've changed. And I mean anything. If they changed a word, if they deleted a word, if they replaced it, they will tell you. They will highlight it. So my recommendation is that you do check that out every January, because part of what the preamble says is that you are going to be responsible for staying up to date with the Code of Ethics. And although you don't have to take class every year, The code of ethics, the preamble establishes that you are responsible for knowing what is in the code of ethics, upholding those principles, and holding each other accountable, right? So make sure that you're keeping up to date with those changes and that you're aware of those changes. Sometimes they're simple, sometimes they're a little more involved. Okay, so that's what's been going on in 2024. So the code of ethics, what is the code of ethics? The code of ethics is your commitment to professionalism as a real estate agent, as a realtor member of NAR. It is recognized as a measure of high standards. So it's setting this bar that all of you are meant to meet and that all of you are meant to hold each other accountable for. So you're meant to hold each other to those standards. And that's again part of what the preamble establishes. The golden thread. So regardless of what kind of realtor you are, commercial, residential, luxury, rentals, I work with buyers, I work with sellers, whatever your specialty ends up becoming, you are all expected to abide by the same code of ethics. So you're all expected to abide by the same 17 articles. They're not going to change depending on what your specialty or your focus in real estate is. It's a living document. And that's what I meant by it being evaluated and updated on an annual basis. So that means that it is constantly evolving and it is not stagnant. And they're trying to take into consideration how the times are changing so that the articles and the code of ethics can reflect that. And then, of course, it's never going to be opposed to the law, right? It's never going to allow anything illegal or go against anything, any law that may be established. Okay. So business best practices. I am going to open the chat for this point, for this part. And this is a judgment-free zone. I'm going to start with that. This is a judgment-free zone. There's no test. We're not taking names, but I want you to go ahead and jump in the chat and tell me if you have read the code of ethics, yes or no. I see a lot of yeses. I see some no's. I see some of you saying, I read some of it. Ooh, someone said twice. I read the code of ethics almost on a daily basis at this point. All right, I'm seeing a lot of yeses, not yet. Okay. I'm seeing like a half and half, yes and no. So the Code of Ethics has a preamble, 17 articles. Most of those articles, not all of them, but most of them have standards of practice. And so, of course, step one is reading the articles. We are going to go through the articles today. I'm not going to go through the preamble. I mentioned a few of the ideas, but I'm not going to read it with you. I am going to read the articles with you, and we'll discuss what the articles are establishing. We're not going to read the standards of practice, but I recommend if you haven't already done so, that you dive into those standards of practice because they can sometimes really, really help with the understanding of what the article is trying to establish. All right. What about our bylaws? Miami Realtors, Miami Association of Realtors has its own bylaws, right? You have your bylaws, your membership code of conduct. How many of you have read the Miami Association of Realtors documents? Those bylaws are readily available on our website. Some briefly, okay? Not yet. So the bylaws in particular, because in professional standards, when someone files an ethics complaint, they can allege that a Realtor member violated an article or articles, but they can also cite the bylaws. And specifically for Miami, it's Article 6, Section 4D. And it's basically saying that you're not going to do anything to tarnish the reputation of realtors, that you're not going to, make threats of violence, moral turpitude is in there. So it kind of addresses some other behaviors that might not necessarily be addressed in the code of ethics. So again, in specific, I would read the bylaws, right? Because you're a member of Miami and those bylaws apply to you, all of them. But specifically for professional standards, I would highlight Article 4, Section 6D. I'm sorry, I said that backwards. Article 6, Section 4D. I inverted that. Article 6, Section 4D. All right. What about the MLS rules and regulations? Because at Miami, you have your association and you have your MLS all together. How many of you have read the MLS rules and regulations? I'm giving you guys a bunch of reading material. Not just the fine schedule, right? Not just the fines that you get for doing certain things, but the rules and regulations. Okay. So those are also readily available on our website. If you go to miamirealtors.com/MLS, you're going to find a bunch of MLS resources, including the MLS rules and regulations. Okay, so those are three things that I'm highlighting for you that you should take a look at and really read through when you have a moment. Those are the articles and their standards of practice from the Code of Ethics, Miami Association of Realtors bylaws, okay, and the MLS rules and regulations. Someone said we should create a syllabus. Well, that's kind of what this is, right? This presentation is available on the orientation page, and it's kind of a syllabus to kind of let you know what your next steps are as a new member. All right, industry standards. We host standards. We host updates for you guys at Miami, right? We have legal updates. We have a bunch of education. We have tech training, but you're also going to get these industry standards from your broker, right? And from maybe your office meetings or whatever onboarding your broker and the brokerage offer their agents. Company policies are obviously going to come directly from the brokerage. Again, that's part of whatever onboarding or orientation they may have had for you at the office. And then federal, state, and local laws, again, you would hear that from your broker, but we also have legal updates. We have a page, miamirealtors.com/legal. You're more than welcome to check that out. While I'm discussing that, I also highly recommend miamirealtors.com/antitrust related to all antitrust questions. There's a bunch of frequently asked questions, FAQs on there, anything new that is coming out regarding the settlements will be posted there. We also host legal updates. So again, miamirealtors.com/antitrust and miamirealtors.com/legal. Okay, and remember, I'm not an attorney. I'm not a broker. I'm not a licensed real estate professional, so I cannot answer any of those questions, but I do want to point you in the right direction and give you the right resources. Okay. All right. Before I leave this page, I do have one more question for you guys. How many of you have already logged in to your gateway? So you logged in, you went ahead and you answered the security questions, you changed your password, you started clicking around on Matrix. Everybody's done that. All right. Well, there's a part where you have to electronically sign that you are in agreement with a few things. Does everyone remember that part? I love how someone sent a salute. Yes. All right. So when you sign or when you become a member and you sign that application, you are in agreement with or agreeing to abide by our bylaws, our membership code of conduct. And in the bylaws, it's built in that you're going to comply with NER's code of ethics and arbitration manual. So you've already signed that you would comply with all of these things, which you have not perhaps read all of these things. So again, my best practice, my recommendation is please read those when you get a chance, because you have already signed that you are agreeing to abide. Okay. All right. So we're all going to read that. We got some homework. If you're having any issues with the gateway, please reach out to membership and MLS so that they can get that sorted out for you. They are open Monday through Friday, 9 to 5, and our MLS also has hours on Saturdays. So someone said something in Spanish in the chat, which kind of alluded to this, which is, once I get to it, the golden rule, right? A lot of it in the code of ethics is tied to the golden rule. We're going to treat other people the way we want to be treated. So let's talk about the structure of these articles, right? So again, golden rule. We all learn this as children. We're going to treat other people the way we would like to be treated. I know that many may not necessarily subscribe to that mentality, but if you subscribe to that mentality, it's going to help curb a lot of potential issues regarding the code of ethics. So the structure of the code of ethics, there are 17 articles, as I mentioned, but there are 3 sections. So those articles are split into 3 different categories: duties to clients and customers, duties to the public, and duties to other realtors. Please note that anyone can file an ethics complaint against a realtor member. So anyone, a member of the public, another realtor, etc., can file a complaint against a realtor member. Okay. Now, we can only process complaints that are filed against our members. So if the person is not a member of Miami, and you send something to me, I will go ahead and let you know that person is not a member of Miami. But just keep that in mind that if you ever find yourself in a position where you would like to file something, you should be filing where that person holds membership. There are 17 articles, right? And those 17 articles are meant to be broad statements of principles that are trying to be established, and it's tied to behavior. And only the articles can be violated. So what does that mean? Article 1, for example, has something like 16 standards of practice. I can go ahead and say Connie is the most unethical person I've ever worked with. This is an example. This is not true. That's not what I think of her. But I can say, okay, Connie was unethical. I want to go ahead and file something against her. I'm going to say Article 1. I could say some of the standards of practice to kind of prove my point, but really the person can only be found in violation of an article. They can't be found in violation of a specific subpoint. Subpoints can be used to kind of define what happened, right? Which are the standards of practice. They're there to help you support and interpret the article, but a person can't be found in violation of a standard of practice. So we're always going to focus on the articles, and the standards of practice are meant to provide some support and clarity, but they're not going to be the one thing that a person is found in violation of, right? They're going to be found in violation of the article. All right. Case interpretations. I mentioned this, and we're going to do a few today, but NAR has case interpretations organized by article and by standard of practice. I highly recommend taking a look at those because they provide like hypothetical situations, and it gives you like a real world frame of reference. What does it look like out in the real world when someone potentially violates that article? They are on NAR's site. Again, they update these. They update the Code of Ethics and Arbitration Manual, and the case interpretations on an annual basis. So again, every January, I would go ahead and take a look and see if they've changed anything. Only look at case interpretations provided by NAR. If they are not cited as being from NAR's case interpretations, please disregard them. Only look at case interpretations that have been sanctioned by NAR. All right, so we're going to jump into the duties to clients and customers. Starting with articles 1 through 3, and most of the articles fall into this category. So for Article 1, and last year, the articles that were found to have been cited most often or violated were Articles 1, 2, and 3. Then the year before that, it was Articles 1, 3, and 12. And the year before that, it was Articles 1, 2, and 3 again. So, and you'll notice that there are similarities between Articles 2 and 12, but Article 1 is usually at the top of the list no matter what. And that's because Article 1 states that when representing a buyer, seller, landlord, tenant, or other client as an agent, realtors pledge themselves to protect and promote the interests of their client. This obligation to the client is primary, but it does not relieve realtors of their obligation to treat all parties honestly. So obviously your first responsibility is to your customer, but that doesn't mean that you get to then treat everyone else differently. You have to treat everyone involved with the same level of honesty and transparency. When serving a buyer, seller, landlord, tenant, or other party in a non-agency capacity, realtors remain obligated to treat all parties honestly. So the one word we hear repeated in this article is honesty. And so it's not a surprise that if you feel someone is potentially behaving unethically, that you would cite Article 1, or that Article 1 would be included. Because if someone is behaving unethically, then chances are they're also behaving in a dishonest fashion, right? So it's definitely at the top of the list because it's a broad enough statement where it can kind of apply to most situations. Article 2, Realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the property or the transaction. So we're not going to exaggerate. We're not going to misrepresent and lie. We're not going to conceal anything. If you are aware or made aware, you need to then disclose that information. How you go about disclosing it, what form you should use, how it should be said, that depends on your broker. And you may need to also contact Florida Realtors legal hotline. But all the code of ethics is trying to tell you is that if you know something, you have to disclose it. It goes on to say that realtors shall not, however, be obligated to discover latent defects in the property. So you don't have to find defects. You don't have to go looking for things. You just have to disclose what you are told. You also don't have to advise on matters outside the scope of your real estate license. You are a licensed real estate professional. Some of you may wear multiple hats. Maybe you're licensed to do other things as well, but you have to stick to what you know, right? And right here, you are a licensed real estate professional. And so if someone asks you as they're looking at a property, oh, I wonder how much it would cost to gut this kitchen and redo it. If you're not a general contractor, an interior designer, a cabinet maker, etc., then you are not to advise on those matters because that falls outside your scope of being a real estate practitioner, right? A licensed real estate agent. You are also not required to disclose facts which are confidential under the scope of agency or non-agency relationships as defined by state law. So you're not required to disclose something that's considered confidential as it relates to state law. So Article 2 is about disclosure. Article 2 is about remembering to stay in your world of real estate, right? You could be very well-intentioned and very well-meaning. It could have a lot of well-meaning behind it, but you want to stick to what you know, right? So we're only going to offer information related to what we know as licensed real estate professionals. Okay, Article 3. Article 3 has code comprehension attached to it. Code comprehension comes from NAR. And what they did is they created kind of like a little fact sheet for some of the articles. Okay, this is what the one for Article 3 looks like. I'm not going to read it, but I do want you to see how they have created these and what they look like. So for this one in particular, they kind of had a Q&A, and then they tied a specific article and the standard of practice to it. So for this one, for Article 3, they related it to standard of practice 3.1. The others are structured a little differently. I'll show you those as well. Okay, let me go back. So Article 3 says realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. The obligation to cooperate does not include the obligation to share commissions, fees, or to otherwise compensate another broker. Again, compensation is negotiable. I am not an attorney. Please go to our antitrust and legal updates pages. This is saying that you are to cooperate with one another. If agents are calling, texting, emailing, requesting showings, etc., you are to cooperate unless for whatever reason, and you can prove that reason, that it's not in your client's best interest. Okay, the obligation to cooperate, again, does not include an obligation to share any sort of compensation. And again, compensation is always negotiable. There are two main ideas that are established or that we kind of reiterate with antitrust, right? All business decisions need to be independently and unilaterally made, and compensation is always negotiable. I am not an attorney. I would highly recommend the next time we have a legal update on antitrust matters that you attend, and that at the very least you look at our antitrust page. Okay, so you would talk to your broker, your attorneys, etc. All right, moving on to Articles 4, 5, and 6. And we're still in the section that's dedicated to duties to clients and customers. Again, for those of you that are asking regarding having multiple licenses and doing other things, I would talk to your broker, Florida Realtors, legal hotline, and or your own legal counsel regarding how you can go about that, if you should go about that, how to navigate. those scenarios. Okay, so Article 4. Realtors shall not acquire an interest in or buy or present offers from themselves, any member of their immediate families, their firms, or any member thereof, or any entities in which they have any ownership interest, any real property, without making their true position known to the owner or the owner's agent or broker. So if you are presenting an offer on your behalf, on behalf of a family member, on behalf of a firm that you're a part of in any way, on behalf of an entity in which you have any sort of ownership interest, you have to disclose that. Again, how you go about disclosing it depends on your broker and or Florida Realtors legal hotline and your own legal counsel, what they advise, but you have to disclose that. The second half of it applies to the other side. So in selling property they own or in which they have any interest, realtors shall reveal their ownership or interest in writing to the purchaser or the purchaser's representative. Okay. So if you are selling anything in which you hold any interest, you need to disclose that as well. I am going to flag Article 4. Article 4 is getting some changes. So they have proposed some changes. They proposed them, I think, back in beginning of May. They are going to vote in October, November. And if those changes are accepted, they will go into effect January of 2025. So Article 4 had some proposed changes to the article itself, to the standards of practice, and I believe they are also contemplating adding a standard of practice. So keep your eye on Article 4. Check back in January because there are some possible changes coming to the language and verbiage of Article 4 and what it says and how it's stated. Okay, so I'm just kind of bookmarking that for you. Article 5, realtors shall not undertake to provide professional services concerning a property or its value where they have a present or contemplated interest, unless such interest is specifically disclosed to all affected parties. So I've always said that 4 and 5 go hand in hand. Whatever filters through Article 4 that is has a potential for special interest kind of gets caught by Article 5, where it kind of broadens it a little bit. So you are going to make sure that if there's any sort of contemplated interest, and that's part of what they're clarifying with some of the changes that they're making to Article 4 is what does contemplated interest mean? They're going to clarify that a little more. Article 4 and 5 kind of go hand in hand. Okay. Article 6, realtors shall not accept any commission, rebate, or profit on expenditures made for their client without the client's knowledge and consent. No hidden fees, right? This is about no hidden fees. We're not profiting off of our customers without our customers' knowledge and consent. When recommending real estate products or services, homeowners insurance, warranty programs, mortgage financing, title insurance, etc., realtor shall disclose to the client or customer to whom the recommendation is made any financial benefits or fees other than real estate referral fees the realtor or realtor's firm may receive as a direct result of such recommendation. Okay, so no hidden fees. And if you're receiving any sort of compensation other than a real estate referral fee, you need to also make sure you're disclosing that as well. Okay. Oh, it went back instead of forward. Sorry about that. Okay, we're still continuing with duties to clients and customers. As I mentioned, the majority of the articles fall into this section or category. Article 7, in a transaction, realtor shall not accept compensation from more than one party, even if permitted by law, without disclosure to all parties and the informed consent of the realtor's client or clients. Okay, so if you're representing multiple parties, multiple sides, they all need to be aware of that. Article 8, realtors shall keep in a special account in an appropriate financial institution separated from their own funds, monies coming into their possession in trust for other persons, such as escrows, trust funds, clients' monies, and other like items. That's just a good rule of thumb when it comes to business. Keep your personal and business accounts separate. Don't commingle funds. Article 9, realtors for the protection of all parties shall assure whenever possible that all agreements related to real estate transactions, including but not limited to listing and representation agreements, purchase contracts, and leases, are in writing in clear and understandable language expressing the specific terms, conditions, obligations, and commitments of the parties. So you have to make sure that all of the agreements that are involved in the transaction are written in a way that is understandable and that is specific about the terms and conditions and the obligations of the parties involved. A copy of each agreement shall be furnished to each party to such agreements upon their signing or initialing. So once everyone is done initialing and signing, everyone gets a copy of that final agreement. We have officially moved into duties to the public. So for duties to the public, we have a couple of things that I'm going to highlight. Article 10, we're going to talk about a little more in a few slides just because it had a big change in 2020. Article 12 has code comprehension, and it's also one of the articles that's kind of up there in the top 3 for us in terms of articles violated. So we're moving into duties to the public. And just know that if you ever find yourself needing to file or wanting to file something against another realtor, you can look at all of the articles. The sections that I'm mentioning are just for organizational purposes. So Article 10 is establishing 3 different ideas. The first one being realtor shall not deny equal professional services to any person for reasons of race, color, religion, sex, disability, familial status, national origin, sexual orientation, or gender identity. And those are known as the protected classes. So realtors are not going to deny people professional services, consumers professional services, because they are of the protected class. Realtors shall not be parties to any plan or agreement to discriminate against a person or persons on the basis of, and then it lists the protected classes once more. So the second idea is that you are not going to participate in a plan or agree to discriminate against someone because they are of the protected class. And the last point that it makes is that realtors in their real estate employment practices shall not discriminate against any person or persons on the basis of, and it goes on to list the protected classes again. So if you're ever hiring someone, you're building a team, you become a broker, you're hiring agents, you need an admin assistant, etc. When you are hiring, you are not going to discriminate against someone because they are of the protected class. So the 3 ideas are: we're not denying someone professional services, we're not agreeing to be a party to any plan to discriminate, and we're not discriminating in our employment practices. Okay, Article 11. Article 11 states that the services which realtors provide to their clients and customers shall conform to the standards of practice and competence which are reasonably expected in the specific real estate disciplines in which they engage. And then they list the real estate professionals, right? So what falls under the umbrella of being a real estate professional, specifically residential real estate brokerage, real property management, commercial and industrial real estate brokerage, land brokerage, real estate appraisal, real estate counseling, real estate syndication, real estate auction, and international real estate. Okay, so you're going to stick to what you know, and we're not going to pretend to know more than we know. Realtors shall not undertake to provide specialized professional services concerning a type of property or service that is outside their field of competence unless they engage the assistance of someone who is competent on such types of property or service, or unless the facts are fully disclosed to the client. So if your client is aware and they still choose to move forward with you, that's fine. But what the article is saying is you can also just bring someone in to the transaction who is knowledgeable and who does know. And if you do so, the end of it says any persons engaged to provide such assistance shall be so identified to the client and their contribution to the assignment should be set forth, right? So you're going to tell your customer, hey, I don't know all that much about this, but I'm going to go ahead and I'm going to bring in Connie. Connie knows a lot about this. She's been doing this for, 10, 15, 20 years. And she's going to help us with all of the transaction documents. And I'm going to go ahead and do all the research for the listings and the properties. Again, guys, anything having to do with what needs to be disclosed and how it should be disclosed, those are questions for your broker, Florida Realtors Legal Hotline, or your own personal counsel. If you don't have your own legal counsel, you can find legal counsel via the Florida Bar. They have a directory and a referral system. Okay. Article 12. Article 12 has code comprehension from NER. Okay, this one looks a little different because the first one I showed you for Article 3 had a Q&A and a standard of practice. This one has a Q&A, a standard of practice, but they also linked it to a case interpretation. So some of these case interpretations, these little code comprehensions, right now they only have them for 3 articles. They're great because it ties it into other things to really help you understand the code of ethics and that article. So Article 12 says that realtors shall be honest and truthful in their real estate communications. Remember I said that Articles 2 and 12 were similar. So Article 2 asks you not to exaggerate or misrepresent. Article 12 is asking you to be honest and truthful in your communication. So we can see how there are some similarities there. You shall present a true picture in advertising, marketing, and other representations. That means social media posts, MLS details, flyers, email blasts, etc. So any kind of advertising, marketing, any kind of representation being made needs to be accurate. It needs to be honest and truthful. Something like MLS statuses, right? An MLS status should be accurate and up to date. And according to our MLS rules and regulations, you have 2 business days to change a status. So if it's active and you get you receive an offer and it needs to be changed to pending or active with contract, you have 2 business days to do so, and that should be done. The article goes on to state that realtors shall ensure that their status as real estate professionals is readily apparent in their advertising, marketing, and other representations. So anytime that you do have something put out there, it needs to be very obvious that it is being posted, shared, etc., by a realtor. It shouldn't be hidden. It should be prominent. It should be obvious. It should not be at the bottom of the page in like 4-point font. Okay? So again, you have 2 business days to make changes to the MLS. If you are noticing that data has not been changed and you deem that it is inaccurate, you have the option of reporting it to the MLS. When you're looking at MLS listing details, at the top, you'll find a yellow caution triangle that allows you to report it. I see Connie just jumped into the chat, and I'm sure she'll finish explaining it, but you can report that, and we encourage you to do so that we can maintain our MLS data. We are only responsible for our MLS data. We are not responsible for how data is represented in other aspects or in other products or in other through other avenues. We can only control what is on our MLS, but please, if you have concerns about that, make sure that you're reporting it to our MLS. We cannot control how often people are updating information, but I can tell you that our MLS updates information within 15 minutes. How often everyone else or every other platform decides to do so, we don't know and we can't control. So back to Article 12, we need to make sure that our representations, everything that we're communicating, very obviously states that it's coming from a realtor, and not just that. Florida Realtors also asks that your brokerage be included. So I'm Maggie Curiel with Miami Association of Realtors. It is very obvious. It's very upfront. It is not hidden. It's not, at the bottom of the page or hidden behind 5 other things. It needs to be very, very obvious. Right? The article also says that the recipients have been notified. So again, that's part of making it very obvious. MLS violations, you have to read the MLS rules and regulations for that. So I'm only here to talk about the code of ethics, which is perceived violations of the code of ethics, potentially unethical behaviors. But again, if you have an MLS concern, you would reach out to them. If something is changed in the MLS by a user within 15 minutes, that information is available to all users of the MLS, but we have no way of controlling what that information looks like outside of that, or how, because of, we can't control how often it's updated by other people. Okay. All right. Moving on. We're past the halfway point, guys. We're almost there. Still dealing with duties to the public, we have Articles 13 and 14. So, realtors shall not engage in activities that constitute the unauthorized practice of law unless you are an attorney and you are bound by your own code of ethics of sorts. You have your own rules and regulations. But if you are not an attorney, even if you know the answer, like you've heard me say, right? I'm not an attorney, I can't answer that. You need to get comfortable with saying that because you do not want to offer a response that could be viewed as legal advice when you are not, in fact, an attorney. So, again, you're going to avoid engaging in activities that constitute the unauthorized practice of law, and you're going to recommend that they seek legal counsel whenever it's in the interest of the party to the transaction. Okay, you have Florida Realtors Legal Hotline. That's for you guys. That's not for the public. But you can also tell them, again, the Florida Bar has a referral system. So they can go and seek legal counsel that way as well. Article 14, if charged with unethical practice or asked to present evidence or to cooperate in any other way in any professional standards proceeding or investigation, realtors shall place all pertinent facts before the proper tribunals of the member board or affiliated institute, society, or council in which membership is held, and shall take no action to disrupt or obstruct such processes. So, if you got an email from us in professional standards from Case Pro and it's asking you to supply a response, it's asking you to, fill out a form, whatever the case may be, you need to comply. This article is telling you that you are required to comply by the Code of Ethics, that you are going to place all of the proper information before the proper tribunal. So there's, when there's a hearing, there's a panel of 5 realtor members like you who have been trained to look at these situations and to make determinations. You cannot avoid it. A hearing, if someone files something against someone and that person chooses not to participate or engage, that hearing can still happen without them. So you can't hide from it by refusing to cooperate. You cannot do anything to actively disrupt the process either, because that in and of itself, all of that in and of itself is a potential ethics violation. Okay. We are now moving into duties to other realtors, and these are the last 3 articles for the Code of Ethics. Not the end of my presentation, though, but it's the end of the articles. Article 15, realtors shall not knowingly or recklessly make false or misleading statements about other real estate professionals, their businesses, or their business practices. If you have nothing nice to say, don't say anything at all. If you're that upset by what has occurred with that realtor member, with that agent, please reach out to professional standards. Do not go volunteering these opinions with, others posting on social media, etc. Please make sure that if you are upset by an interaction or a situation, that you are coming to professional standards and reporting it. And if you have nothing nice to say, please do not go around town and social media posting about it. Okay, Article 16. Article 16 is one of the most misunderstood and misinterpreted articles. So much so, remember the Code of Ethics comes from the National Association of Realtors. So the National Association of Realtors has a code comprehension for Article 16, as you can see. And this one is a little bit longer than the others. Okay, Article 16. This has 2 Q's and A's, okay, and a standard of practice. So this is a 2-page code comprehension tied to Article 16. Oh, went too far. Okay, now, Article 16 was also so misunderstood that the state association, Florida Realtors, decided to step in and create materials to help realtors understand Article 16 because it was being misunderstood so often. Article 16 says that realtors shall not engage in any practice or take any action inconsistent with exclusive representation or exclusive brokerage relationship agreements that other realtors have with clients. We're not going to step in to a relationship that's already been established with another realtor, right? Exclusive representation. That's the key phrase there. I want to take a moment to recommend a few classes. The first one being understanding the buyer broker agreement. We're offering that regularly. So again, understanding the buyer broker agreement. That's tied to Article 16. The other class that I'm going to recommend is the ABR accredited buyer's rep. Okay. So 2 classes I'm recommending.
Which
Understanding
one was
the buyer,
first one, Maggie?
understanding the buyer broker agreement.
Okay, I'm gonna try to send them links to both, okay?
Perfect. And the second one is ABR. So Connie's going to find some links to send you guys if you're interested in signing up for that. We have them on the calendar and they're on pretty regular rotation. But I highly recommend those 2 specifically tied to Article 16. Now, remember I mentioned that it's so misunderstood that not only did NAR provide code comprehension, but then the Florida Realtor stepped in and said, we're going to lend this a helping hand because people really need to understand Article 16. So let me pause this to make sure that I've connected the sound correctly. Okay, and this is a video that Florida Realtors created to help people understand Article 16.
Hello and welcome to Think It Through. This Florida Realtors educational series explores the Realtor Code of Ethics. In each episode, you'll observe real-life situations where the code may provide guidance on what to do. You'll watch a scene, we'll break down elements of the code that apply to the situation. Then we'll challenge you to think it through to arrive at the proper course of action. The Code of Ethics. It's more than a point of pride. It's what sets realtors apart. It's the way you do business the right way. This episode is based on case 1622, ascertaining whether a consumer is subject to an exclusive representation agreement. Hello and welcome to Think It Through. Today we're observing a listing agent just after showing her listing to a buyer. So, what do you think?
It's really nice, but honestly, we were looking for more of a fixer-upper.
I see.
So proud of my husband. He did most of the remodeling on our last 2 properties.
Wow, impressive. You know, I might have the perfect property for you. I just took the listing this morning, and it is definitely what I would consider a fixer-upper. It's not far from here. Let me show you.
We should probably tell our realtor about the other property.
Hold it. Let's think it through. Article 16 of the Code of Ethics says, realtors shall not engage in any practice or take any action inconsistent with exclusive representation or exclusive brokerage relationship agreements that other realtors have with clients.
We should probably tell our realtor about the other property.
It is unethical for me to work with buyers who are working with other realtors. I can't talk to you at all anymore.
Does the code say what the listing agent thinks it says? Standard of Practice 16.9 says, realtors prior to entering into a representation agreement have an affirmative obligation to make reasonable efforts to determine whether the prospect is subject to a current, valid, exclusive agreement to provide the same type of real estate service. The listing agent said it was unethical to work with buyers who are working with other realtors. Period. The end. Mic drop, walking away. But think it through and notice that's not exactly what the code says. It says prior to entering into a representation agreement, realtors need to make reasonable efforts to find out if the buyers have an exclusive agreement with their realtor. Keyword, exclusive. Clearly, the code does not say what the listing agent thinks it says. Fact is, the code does not define reasonable efforts.
So, next time a buyer says something like,
We should probably tell our realtor about the other property.
What will you do? We strongly encourage you to think it through.
All right, so It looks like Connie already shared some links with you guys. So highly recommend that you check those out.
Can I say
And the,
something, Maggie, a
of
second?
course, of course.
I tried to send all of you the entire calendar so that you could see all possible dates, not just one date. And what
Okay.
I sent you was a link that provided to you all dates. So I was trying to take you to navigate so that you can see all the possibilities that you have available, not just one date. So please notice that the links I provided are actually for you to see the buyer agreement and the accredited. And if you take the calendar and you start to look, you're going to see everything that's available, not just one date, July 2nd. If you scroll down, you'll see the 18th and more. Maggie and I are trying to provide you additional information to make it easier for you to attend.
Thank you, Connie. So, and listen, it's super easy. miamirealtors.com/calendar. Anytime you go to our website, you put / the name of a product, its apartment, etc. It's going to take you to a page for that. So we've set it up where it's pretty easy to navigate. And that calendar has a great search bar. So you can type in, you can look by location because it has tags. You can look by, instructors. Sometimes you have favorites. Don't worry, none of us take it personally. You can look by the topic, so there's a bunch of different ways to search, but that calendar is jam packed with goodies. Okay, it's jam packed with education for you, both, CE or not both, but CE, any training, legal updates, tech training, etc. Which I know Connie talks to you about it in her presentation, but once you get in there and start using it, you'll see what we mean. All right, Article 17 is the last article that we're going to read together before we start talking about other things regarding the Code of Ethics. In the event of a contractual dispute, okay, or specific non-contractual dispute as defined in Standard of Practice 17.4 between realtor principals. Realtor principals are usually brokers. It can be branch managers. It can be stakeholders in the company. Realtor principal applies to a few different people. Usually it's the broker. Associated with different firms, so different brokerages that arises out of their relationship as realtors. We can't handle something that happened outside of, real estate. The realtor shall mediate the dispute if the board requires its members to mediate. We do have mandatory mediation at Miami. If the dispute is not resolved through mediation, realtor shall submit the dispute to arbitration in accordance with the policies of the board rather than litigate the matter. So if mediation doesn't resolve the issue, it goes ahead and it moves into an arbitration hearing instead of going to court. In the event clients of realtors wish to mediate or arbitrate contractual disputes arising out of real estate transactions, realtor shall mediate or arbitrate those disputes in accordance with the policies of the board, provided the clients agree to be bound by any resulting agreement or award. So this can be invoked for your customers. Doesn't really happen, right? It can. Haven't really seen it happen. But as long as they're agreeing to abide by whatever is decided, then we can move forward. The obligation to participate in mediation and arbitration contemplated by this article includes the obligation of realtor principals to cause their firms to mediate and arbitrate and be bound by any resulting agreement or award. So when a realtor principal, usually a broker, doesn't have to be a broker, but they're usually a broker, when they invoke arbitration with the association, that means that they are also causing their firms, their brokerages, to mediate and arbitrate, and their firm and brokerage that is going to abide by the resulting agreement or award. Okay, we are done with the 17 articles. We still have a few more things to discuss, but I know that going through the articles is not necessarily the most entertaining aspect of this. Not that any of it is, but we're going to get into some other interesting things. So what I'd like to do right now is give you guys a break. Let's go ahead and give you let's do a 10-minute break, right? Be back. It's 11, almost 40. So let's be back online by 11:50 and ready to go. Okay. So 11:50, we're taking a break. All right, and we are back. So for those of you that stepped away, if you can hear my voice, come on back. All right, and we're going to continue. Perfect. Thank you for confirming that you can hear me. Appreciate it. All right, so let's keep talking about all this fun stuff. Let me get my mouse to cooperate. All right. So some of the changes that we've seen with the standards of practice, or that we've seen in professional standards in the last few years. So standard of practice 10.5 was added in 2020. And this is what I mean by some changes are bigger than others. I think it was last year. So for 2023, they made a change where they updated one word in Article 10. And they changed a word that they felt was outdated and they replaced it. Okay. But a few years before that, they had added a whole standard of practice, right? So sometimes it's just a word, sometimes it's more than that. So for this standard of practice, what they did was they added one that specifies that realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, disability, familial status, national origin, sexual orientation, or gender identity. So again, in terms of speech, it is asking realtors not to use harassing speech, hate speech, epithets, or slurs that are based on a person being of these protected classes. That was one of the changes. Okay, another change that we saw in the last few years, policy statement 29. So we have this entire manual, we have all these rules and regulations, we have the code of ethics, etc. What does it mean to have a policy statement? So they have these policy statements that are meant to kind of clear up or specify how something is to be applied. And so what they did was this policy statement specifically used to say that realtors were encouraged to follow the principles of the code of ethics in their day-to-day life, but they were only subject to disciplinary action if what they did was tied to a real estate activity or a transaction. So they kind of expanded it a little bit. And they said that realtors are subject to disciplinary action under the code of ethics with respect to all of their activities. So if this behavior occurs in or out of a real estate related activity, you are still subject to disciplinary action. Now, keep in mind, most of the articles are very specifically tied to real estate transactions and real estate dealings. But there are things that kind of fall outside of that, specifically tied to things like Article 10. You are expected to uphold these principles all the time, no matter what. Okay. The other thing that they changed or have changed recently is that they redefined public trust or a violation of public trust. So public trust used to be defined as demonstrated misappropriation of client or customer funds or property. Okay, demonstrated. Willful discrimination or fraud that resulted in substantial economic harm. So they took that definition and they kind of opened it up. So now public trust or a violation of public trust is all discrimination. All discrimination, willful or not, all discrimination, all fraud, regardless of whether or not it resulted in substantial economic harm. Because NAR considers these to be quote unquote particularly egregious violations. Now, what we do in professional standards is confidential, and the confidentiality of it all is defined under Article 14 and the standards of practice for Article 14. In these situations where there is a violation of public trust, where there is fraud and the person is found in violation, where there is discrimination and the person is found in violation, what we do normally stays in-house. But for those situations, we are then to report it up to FREC, which is the Florida Real Estate Commission, because they're a violation of public trust. Now, what does that mean, or why is that? In professional standards, and we'll talk about it later, the discipline includes things like fines and education and possible suspension. But FREC can suspend licenses, can revoke licenses, and that's not something Miami can do. So remember, Miami Association of Realtors is not the governing body that issues real estate licenses, right? We don't do that. What we do is we offer you the resources you need to maintain your license, right? Like CE classes, but we do not renew your license, issue your license, suspend or revoke it. That is something that FREC and ZVPR can do. So in these situations, because NAR feels that they are particularly egregious, that they're that bad, they then are requiring that we take that violation once a violation has been found, and that we share that with FREC so that FREC can conduct their own investigation and then do whatever they deem necessary. Now, there were some concerns when these changes first came out, specifically tied to Standard of Practice 10.5. And so this was an FAQ that NAR had published. And it states, this proposed new standard of practice 10.5 seems to limit my free right, or my right to free speech, as established by the First Amendment to the Constitution. How can NAR legally adopt a policy like this? It says the First Amendment provides that neither the United States Congress nor any state may abridge the freedom of speech of American citizens. With some exceptions, the First Amendment does not prohibit a private organization from restricting the speech of its members, employees, or users. NAR is a private association that is supported by dues from members, is not exercising any governmental function, and has no subpoena powers generally available to state agencies. As such, the First Amendment does not preclude NAR from imposing this ethical duty as a condition of membership. So NAR is not a governing body that normally would have powers like other governing bodies, like, subpoena power. And this is a membership-based organization. And so one of the conditions of membership is that you comply with the code of ethics and that you comply with what they're asking of you. And this is, again, an FAQ that came directly from NAR. And these changes are only applicable to things that occurred on or after November 13th, 2020, can't be applied retroactively to anything that may have occurred before then. All right, so the Professional Standards Committee. Let's talk about what happens when we have complaints and requests for arbitration filed. So association staff, that's me, that's the professional standards team. All communication and case administration flows through us. Parties do not talk to our volunteers directly. And I say volunteers because the people who look at these complaints and these requests and ultimately make decisions are realtors like you, who have been trained, who have volunteered their time. They are not compensated. They're doing this because they want to maintain the integrity of the profession. You don't communicate with them directly, right? The parties do not communicate with them directly. They communicate with association staff, someone like myself. And then we can answer procedural questions, but we are always neutral. So we do things like explain the process. Like, okay, this is what you're going to do to file. This is what's going to happen next. This is, what's going to happen next. We tell you what forms to fill out. We tell you how to upload it. We tell you where to go to see everything procedural, right? But we can't tell you someone did or didn't violate the code of ethics. We can't tell you what to do. Should you or should you not file? Who should you name? We cannot tell you any of that. We are neutral. I am Switzerland. I am here to help you understand the mechanics, but I'm not here to help you with the content, okay? So we make sure that the procedure is followed. So that manual that I mentioned, I have that manual on my desk or open on my computer digitally as well. And I have it on my iPad. That manual governs everything I do. And so if I need to double check anything, the manual is where I'm going to go, and I'm going to make sure that what the manual says needs to happen is what's happening. We also process filing fees. We don't have filing fees for ethics complaints. So when someone files an ethics complaint, there is no charge, there's no filing fee. But for a request for arbitration, there is. So a request for arbitration ultimately is a commission dispute. That has a $500 filing fee. If you decide to appeal a decision from a hearing, whether it's an ethics hearing or an arbitration hearing, which is called a procedural review, there's a $500 filing fee for that. Someone in the chat said, I want to learn about contracts and listings, like listing contracts. Which class should I recommend, or would I recommend for that? There's a couple, but there are classes like the as is contract class. There's a FAR bar class. There's a listing presentation class. So go to our calendar. Remember, you can search our calendar by topic, name of the class, location, instructor, etc. So I would go in and I would go to the calendar and type in contract or contracts. And any class that mentions contracts in the description is going to be what's left on the screen. So I would definitely make use of the search bar. Okay. All right. The last thing that I want to again reiterate is that as association staff, as the professional standards administrator, I do not make determinations regarding the merits of a complaint. So if you email me and you're like, Maggie, I don't know if I should or shouldn't file, I am not going to tell you yes or no either way. I'm going to tell you if you would like to file or when you decide to move forward with filing, this is the link for you to go ahead and do so. We're just making sure that the process is there and that the same procedures are afforded to everyone. So you come to professional standards and you say you have an issue with an agent, the first thing we're going to do is offer you ombudsman services. So this is a little visual chart. Okay, if the ombudsman is able to resolve the issue, that's where it can end. And if they cannot resolve the issue, then we share the steps with you to file a formal complaint. The ombudsman is a little more informal. So what is an ombudsman? Right, an ombudsman is a person, again, it's one of our realtor volunteers, and they are there to help you resolve the dispute through communication. It's very informal, it's a phone call. They're going to call you, introduce themselves to you. They're going to ask you what happened. They're going to ask you if you're okay with them calling the other person to try and resolve the issue. So they're going to try and get all of the background story as much as possible. The whole point is for everyone to reach some sort of consensus. A lot of times these potential issues stem from frustration, lack of communication, miscommunication. And so an ombudsman steps in to kind of bridge that gap. Okay? Now, the ombudsman is there to help with communication. They are not there to decide whether or not what that other person did was right or wrong. They're not there to decide if there was a violation or not. They are there to identify what the issue is, to help resolve any misunderstandings that could eventually become formal complaints. But they're not there to determine if there was a violation, and they're not there to determine if someone owes someone else money. Okay? That is not their role. Their role is primarily conversation, it's a phone call, and that's it. Now, when they report back to the association, they don't even tell us what was discussed. All they tell me is, Maggie, it was resolved or it wasn't resolved, and this person would like to move forward. Please send them the steps to file a formal ethics complaint. I do not know what was discussed. What was discussed is not discussed with anyone else. And usually ombudsmen are dealing with just general questions. They're going to go over the details of the transaction. They might make recommendations, right, about ethical best practices, like, hey, it might be a good idea to do this, right? But they're not going to tell anyone that they were right or wrong. They're not going to enforce anything, but they might remind people of what the code of ethics says and just general questions, especially when it's a member of the public and they don't have a lot of real estate knowledge or any at all. An ombudsman can be really helpful. So once the ombudsman is done, they come back, and again, they don't tell us what was discussed. They just tell us whether or not the person wants to move forward with filing an ethics complaint. The complainant, the person who comes to me and says they're having issues, does not have to accept the services. They can tell me, you know what, Maggie, I really don't want to talk to an ombudsman. I just want to file a complaint. They are well within their right to do that. The formal ethics complaint continues until you tell us otherwise. So this is a process. We have a lot of members. We have, busy schedules. Our volunteer members have their own schedules. So trying to coordinate that can be interesting at times as well. All that to say that these issues are not resolved overnight. And so what ends up happening is we continue the process. Sometimes people forget about it. And then when it comes time for the hearing, they're like, oh, I ended up talking to them and it's resolved. Or, you know what? I'm not really mad at them anymore. I don't want to do this anymore. You have to fill out a form and withdraw your complaint. But you have to tell us. Because otherwise we are going to keep it moving forward for you. The complainant can resubmit the complaint. So even after you talk to an ombudsman, if you felt that it resolved the issue and then something else happens, or you keep thinking about it and you're like, you know what, this doesn't sit well with you, you can still come back and say, I talked to an ombudsman and I felt it was resolved, but I want to file. Again, you're well within your right to do so. Someone asked, does the ombudsman deal with the public as well? Yes, the ombudsman can speak to members of the public because remember, they can file an ethics complaint. And so the first thing that we're going to do when they come to us with a potential complaint is offer them an ombudsman first. So yes, an ombudsman can talk to a member of the public who may have an issue with a realtor member. So the ombudsman is not going to refer the concerns to anyone else. As I told you, they don't even tell association staff. They just tell us it was resolved or not. They're not going to talk to the grievance committee, which is the next step. They're not going to talk to the licensing authority, which is the DPR and TREC. It kind of everything in professional standards is one and done. That person touched and handled that case once. They are not going to handle that case again. They're not going to see it again. They're not going to find out what happened. So they only look at it once, and every time that case is looked at in the next step of the process, it is looked at by a different set of eyes so that there's no tainted prejudgment, right? There's no bias. So this is to make sure that there's impartiality. Okay, so back to my nice little visual. My visual shows you, all right, the ombudsman resolved the issue. Great, that's where it can end. Remember, you can still come back and change your mind to file. They didn't resolve the issue. We send the steps to file an ethics complaint, right? You're going to file the ethics complaint, and the ethics complaint is going to go to our grievance committee. Our grievance committee is made up of 20 to 25 individuals. They are not the ombudsman. The ombudsman is not going to touch this case again. Remember that. They are going to look at the complaint, and the only question that they're going to ask is, given what we are being told, should we forward this to a hearing? So they are still not deciding whether or not there was a violation of the code of ethics. They're just deciding whether or not it merits a hearing. Okay? So what is the grievance committee going to do? The grievance committee is going to review these ethics complaints, and they're going to determine if, like I said, a full due process hearing is warranted. And they are going to determine if the complaint is a violation of the articles that were cited. So based off of what the complainant has said, we are dealing with perceived unethical actions and behavior, unethical conduct. They're going to look at the forms and decide if they are in proper form or not. Our system that we use online basically you supply the information and it fills in the blanks for you. So it takes care of that first step. Are the right parties named, right? Did you name someone who's a member of Miami or not? Did you name someone and forget to name the other one or not realize that you didn't name the other person? So they're going to determine if the right parties are named. They're going to look at filing deadlines. The magic number in professional standards is 180 days, and that is 180 days from the date the transaction closed or 180 days from the date that you could have become aware of the issue in the exercise of due diligence. That's what the manual says, almost verbatim. So 180 days either from the date that you discovered the issue or the date the transaction closed. Litigation or governmental investigations. When you have an issue, you can file something with us. You can file something with DBPR. You can go to a court of law and file a lawsuit. You are well within your right. You have the option of doing everything. 1, 2, or all 3. That being said, if there is something filed anywhere else and our grievance committee decides that the issue could move to a hearing, we are going to pause the process. So the grievance committee is going to say, we're going to move this forward, but we're going to put it in abeyance. And what that means is Again, the process is paused and it's kind of set aside until you finish with everything else. Once you finish with everything else, you let us know and then we pick up where we left off. But we search for issues or lawsuits that have been potentially filed in Dade, Broward, and Palm Beach. We make sure we have enough people to serve. Luckily, we have, a big association. We have plenty of volunteers. This is more of an issue for maybe smaller associations. And then they determine whether or not the right articles are named. So the grievance committee could add or remove articles according to what they see based off of what you submitted. Okay, our grievance committee meets once a month. They go through all the cases. I've seen them go through as few as like 10 to 15 cases and as many as almost 40 cases a month. So every month they go through, they read each and every case, they read each and every item that has been submitted by the person filing the complaint. That person is known as the complainant. The person they file against is the respondent. If it is moved forward for a hearing, that is when the respondent is notified. Okay, so just because someone files, sometimes people are worried about filing and they're worried about whether or not it's going to move forward and they don't want the other person to know unless it's going to move forward. That's not an issue. Okay, so when you file something, we do not tell the other person until the grievance committee has reviewed the complaint and determined that it should go to a hearing. Okay, and then we'll tell the other person and we'll ask them for their response and we'll move along in that sense. But if they dismiss the complaint, you can appeal that. There is no charge for that. It's reviewed by members of our board of governors, and they'll look at your explanation as to why you feel it should not be dismissed, and then determine whether or not the dismissal should hold or if it should go back and maybe go to a hearing. The complainant can provide an explanation of why you disagree, but you cannot provide additional information. So it's based off of the same information that the grievance committee had. So the board of governors can look at exactly what the grievance committee saw and why they made their determination, and then figure out if that determination should be upheld or overturned. So what happens when it's forwarded to a hearing? The ethics complaint is going to have a full due process hearing. It's going to be fair, it's going to be unbiased, it's going to be impartial, and it's going to determine whether or not there was a violation. So at this point, if you followed the entire track, right, for a potential issue, you get an ombudsman, it's one person, it's a phone call. They're going to call you, call the other person. If that doesn't resolve the issue, you file a formal complaint. That formal complaint is in writing. It is then reviewed by the grievance committee, 20 to 25 people. Those people are different. They have not seen this. This is their first time seeing it. They're going to determine whether or not there should be a hearing. And then if they determine that there should be a hearing, the matter goes to 5 individuals, minimum 3. And those are 5 different people. And again, they have no knowledge. They don't see anything until they're assigned to the case and they start reviewing the documents before the hearing. Now, they're the ones. It's at that point that after a hearing, a determination is made as to whether or not there was a violation of the code of ethics. So at an ethics hearing, a respondent, and again, a respondent is the person who the complaint was filed against, right? Because they are responding to the complaint. They are considered innocent unless they prove otherwise. And the burden of proof in an ethics complaint is clear, strong, and convincing, and it's on the parties. So the complainant and respondent are responsible for proving whatever their stance is. Our volunteers and association staff, we don't investigate, we don't go searching for anything on the MLS, on Google, on whatever. We just make sure there's no pending lawsuit. But other than that, like, there's no investigation. So it is up to each of the parties, and the burden of proof is on each of the parties, and it has to be clear, strong, and convincing. There can be no room for doubt. So what happens at an ethics hearing? Again, it's a panel member of 5. Those 5 people were not on the grievance committee. Those 5 people are not the ombudsman. These are 5 brand new people. It can be minimum 3. And there's always a chairperson. That chairperson is going to read a script, and that is the same script that is read at every hearing. That way, every hearing is the same, and every party, whoever participates in any of our hearings, has the same procedure offered to them each and every time. The parties make opening statements, which is a summary of what occurred. After they've made their opening statements, they can then call in their witnesses. You can have witnesses, you can have attorneys, optional, but you can have attorneys. Once you present your case, you are cross-examined by the panel and the other party. So you can ask questions. Then the closing arguments are made, a summary at the end. The parties are dismissed. The complainant and respondent are dismissed, and the panel stays behind in what's called executive session to discuss the testimony, discuss the documentation, and determine whether or not there was a violation of any of the articles that were cited. There could have been no violation at all. There could have been a violation of some articles, but not others. It just depends, and they'll decide what violation occurred, or what was proved to have occurred. This is the discipline they are authorized to select from. There's a letter of warning, which is just that. It's a warning. It stays on your file. It is confidential, so we're the only ones that know it's there. And it stays on your file for a year. And the manual exercises what's called progressive discipline, which means that with each violation, things will progressively kind of move up the chain of discipline. The other option is a letter of reprimand, which can stay on a file for 1 to 3 years. And that is then combined with any of the additional sanctions and discipline that you see listed below. So they can ask you to attend the code of ethics again. So a class like this one, they can ask you to attend other classes. They can ask you to, take an MLS class or take, an NAR class. They can fine you up to $15,000. If you are found in violation, there's a $250 processing fee, and then $500 for any violation after that. They can suspend your membership for 30 days to a year. They can expel you from your membership from 1 to 3 years, and then you would have to reapply. They can suspend your access to the MLS for 30 days to a year, or they can terminate your access to the MLS for 1 to 3 years. So again, if we're looking at an ethics complaint, we went from an ombudsman to, I just keep dropping stuff. Sorry about that. I'm dropping my mints that are on my desk. We have an ombudsman. It's gonna resolve the issue, hopefully. If it doesn't, you file your complaint. If you file your complaint, it goes to grievance. Grievance committee decides if it needs a hearing. If it needs a hearing takes place. We discuss what happens at a hearing. And then after that, if you don't agree with the decision, you can file an appeal. Now, if you don't agree with the decision, let me rephrase that. You can file an appeal if you feel that there was a procedural deficiency or a lack of. You cannot file an appeal because you don't agree with the decision. Okay? So an ethics appeal has to be based off of procedural deficiency or lack of due process. You have a witness, you told us about the witness ahead of time like you were supposed to, and the chairperson didn't let you bring your witness in. You didn't get a chance to cross-examine the other, something along those lines. Okay, there's a step in the process that got skipped with you for whatever reason, and because of that, you feel that your hearing wasn't fair. A perceived misapplication or misinterpretation of one or more of the articles. You're found in violation of an article and you feel that the hearing panel misapplied that information. So they misinterpreted the article. Or the nature or gravity of the discipline. You feel that the discipline is too severe, and so you appeal that. The fact that a hearing panel found no violation is not appealable. So if you file an ethics complaint and it is determined that there was no violation, you cannot file an appeal simply because you do not agree with their decision. Okay, we're going to move on to arbitrations now. So request for arbitration is tied to a commission dispute from a real estate transaction. You file the request for arbitration. The request for arbitration must be filed by your realtor principal against the realtor principal of the other agent. I'm going to say that again because the biggest issue with request for arbitration is the wrong parties being named. Your realtor principal, which is usually your broker, not always, but usually your broker, will file the request for arbitration against the realtor principal for the other agents. Why? The listings ultimately belong to whom? The brokers. Compensation ultimately flows through the brokers. And so if this is a commission dispute, then it would be realtor principal to realtor principal. You're going to file a request for arbitration. There's no ombudsman for this. There's nothing like it for it. You just go ahead and you file. Once you file, then it is determined whether or not it should move forward. If it moves forward, it'll go to a mediation first before it goes to a hearing. Now, please remember that there's a $500 filing fee for a request for arbitration. And if it moves forward, the other side is also expected to pay their $500 filing fee. The arbitration has to fall within the parameters of Article 17 and the standards of practice for Article 17, which lay the framework for who can file requests for arbitration and the scenarios for which you can file. And it is usually a contractual dispute involving money arising out of a real estate transaction. Arbitration is between realtor principals from different firms, different brokerages. What is a realtor principal? The manual defines a realtor principal as a licensed or certified individual who is a sole proprietor, a partner in a partnership, an officer or majority shareholder of a corporation, or the office manager, including branch office managers, that are acting on behalf of principals of a real estate firm. Again, it's usually the broker, but everyone else or every other role named in this definition could also be a realtor principal. They are usually listed on DBPR as qualifying brokers. And on Sunbiz, when you search the brokerage, they are listed as corporate officers. So if you don't know who it is or your broker doesn't know who it is, you can find them that way. I cannot tell you. So you cannot come to the association and say, well, I don't know who to file against because I cannot tell you who to name. Okay? Because we administer the processes for professional standards, we have to remain neutral. So you have to determine who you are going to name. We cannot tell you who to name. But again, you can search DBPR. They're listed as qualifying brokers. You can search Sunbiz. They're listed as officers for the company. And I'm sure you can find other ways or other resources and platforms where people are named as the brokers or the branch managers and then move from there. But I cannot tell you who to name. So once the grievance committee gets this request for arbitration, they're going to review it and determine if it needs a hearing. And they're going to look at it and determine whether or not it is tied to a monetary dispute that came about because of a real estate transaction. So they're going to see if it's in proper form. Again, the form is filled in as you go through the steps in our system. Are the appropriate parties named? This is one of the biggest reasons that there are delays in processing requests for arbitration because the grievance committee will send it back to you and tell you that you have not named the appropriate parties and give you an opportunity to make corrections. They make sure filing deadlines are followed. Again, that's 180 days from the date the transaction closed or 180 days from the date that you determine something occurred, whichever is later. Litigation, we make sure you aren't actively also suing each other. We make sure we have enough people for our panels. And then there's a checklist of questions. And on that checklist is, is it in the proper form? Are the right parties' names? Is the amount in question too large or too small? Is there pending civil litigation? Is it too legally complex? Have they filled out the forms, right? Agreeing to mediate and agreeing to arbitrate. If all of those are checked off and it falls within the parameters, then it is moved forward to a hearing. So again, 180 days from the closing or the realization that a dispute existed, whichever is later. So if it moves forward, it's going to go to a mediation first. The mediation is generally on Zoom. We are now moving to in-person, again, at our global headquarters. We have mediation rooms and a hearing room. It's specifically designed for professional standards proceedings. These proceedings are not recorded, and what will happen is the mediator will try to facilitate a negotiation of a resolution. Okay? So the mediation officer is neutral. They don't know what's going on. They're going to hear it from you first. And they're going to allow each side to say their part, right? And explain the process. So the mediator is going to come in, introduce themselves, ask you to introduce yourself. They're going to explain the process. They're going to make their statements. They're going to allow the parties to explain what happened one side at a time. They're going to identify what the issue is. The parties want to kind of talk at any point in time. Parties can say, we want to mediate this. We want to try and do this on our own, right? That's entirely possible. And you're always encouraged to mediate and find a solution. And you can find a solution before it gets to a hearing. Then it's going to break out into caucus. What happens is we will place each party or each side in different rooms, and the mediator will go from room to find a solution and hopefully reach an agreement. If they reach an agreement, each party gets their $500 filing fee back. So that is refunded if they reach an agreement. If they do not reach an agreement, then it goes to an arbitration hearing. Again, remember, each step of the process is different. So the grievance committee that looked at this originally is not going to be, none of those people, or will be a mediator. That mediator, if they don't resolve the issue, that mediator will not be on the arbitration hearing panel. So it's going to go to an arbitration hearing. The arbitration hearing is structured the same way as an ethics hearing, except here, the main goal is not to determine if there was a violation, but to determine who should be awarded the funds, if at all. So parties make opening statements, they can call in their witnesses, they can have attorneys, they can cross-examine each other, they can present all their testimony, all their witnesses, they make their closing arguments, they're dismissed, and then the panel will stay behind an executive session to determine who should be awarded the amount in question, if they should be awarded anything at all. The panel here, again, it's 5 people. There's a chairperson, minimum 3. There's a script. It's the same script every time. So again, the same procedure is followed each and every time. So they're going to determine who the prevailing party should be. It cannot be more than what was requested. It can be less. And in this situation, instead of an appeal, you can file what's called a procedural review. And a procedural review is just that. It is a review of the procedure. You are claiming that there was some part of the procedure that was not afforded to you, and that affected the results of the hearing. You cannot file this because you didn't agree with what they decided. Okay? All right. So let's talk about the case studies. The case studies, remember, are case interpretations from NAR. We're not going to do one for every article. I have, a handful of them that I'd like to do with you. And then what I will ask of you is that in the chat, you go ahead and you actively participate and let me know if you agree that it is or is not a violation. Okay, so this first case interpretation is tied to Article 1. Article 1, remember, is related to honesty. And in this case interpretation, it says, as the exclusive agent of Client A, Realtor B offered Client A's house for sale, advertising it as being located near a public transportation stop. Prospect C, who explained that his daily schedule made it necessary for him to have a house near the public transportation stop, was shown Client A's property, liked it, and made a deposit. 2 days later, Realtor B read a notice that the transportation running near Client A's house was being discontinued. He informed Prospect C of this, and Prospect C responded that he was no longer interested in Client A's house since the availability of public transportation was essential to him. Realtor B informed Client A and recommended that Prospect C's deposit be returned. Client A reluctantly complied with Realtor B's recommendation, but then complained to the Association of Realtors that Realtor B had not faithfully protected and promoted his interests. That after Prospect C had expressed his willingness to buy, Realtor B should not have made a disclosure that killed the sale, since the point actually was not of major importance. The new transportation route he showed would put a stop within 6 blocks of the property. In a hearing before a hearing panel of the association's Professional Standards Committee, Realtor B explained that in advertising client A's property, the fact that a transportation stop was less than a block from the property had been prominently featured. He also made the point that Prospect C, in consulting with him, had emphasized that Prospect C's physical disability necessitated a home near a transportation stop. Thus, in his judgment, the change in routing materially changed the characteristics of the property in the eyes of the prospective buyer, and he felt under his obligation to give honest treatment to all parties in the transaction, that he should inform Prospect C, and in doing so, he was not violating his obligation to his client. So I now pose the question, someone already jumped in and answered, do you think that Realtor B is in violation of the Code of Ethics? Okay, I see no, not a violation. Someone has some choice words about the seller. Someone asked, what does it near mean? Well, we don't have those details. So based off of just what we discussed, right? I don't have any additional information to offer. Okay, so I saw a lot of no's. The hearing panel concluded that Realtor B had not violated Article 1, but had acted properly under both the spirit and letter of the Code of Ethics. The panel noted that the decision to refund Prospect C's deposit was made by the seller, client A, even though the listing broker, Realtor B, had suggested that it was only fair due to the change in circumstances. Okay, so for all of you that said no, you were correct. Article 2, remember this is about avoiding exaggeration, misrepresentation, or concealment of pertinent facts. If you know something, you say something. Realtor A, acting as a property manager, offered a vacant house for rent to a prospective tenant, stating to the prospect that the house was in. Shortly after the tenant entered into a lease and moved into the house, he filed a complaint against Realtor A with his association of realtors, charging misrepresentation since the clogged sewer line and a defective heater had been discovered, contrary to Realtor A's statement that the house was in good condition. There's a slide that got skipped there. Or it got moved around. Sorry about that, guys. There we go. At the hearing, it was established that Realtor A had stated that the house was in good condition, that the tenant had reported the clogged sewer line and defective heater to Realtor A on the day after he moved into the house, that Realtor A responded immediately by engaging a plumber and a repairman for the heater, that Realtor A had no prior knowledge of these defects, that he had acted promptly and responsibly to correct the defects, and that he had made an honest and sincere effort to render satisfactory service. It was the hearing panel's decision that Realtor A was therefore not in violation of Article 2. The house was in good condition. The tenant had reported the clogged sewer line and defective heater. They responded immediately. They had no prior knowledge. So in this situation, sorry, there was a slide that got deleted, but it was the hearing panel's decision that it was not a violation of Article 2. So the slide that disappeared from here basically explained that they had called a plumber and that they had called a repairman and that they had very quickly resolved the issues that were reported by the tenant. And because of this, it was determined that it was not a violation of Article 2. Right, these issues didn't exist before the move-in, and the realtor was quick to resolve the issues for the tenant. Article 3, remember this is about cooperating with others, and that cooperation does not obligate anyone to share commissions, fees, or to otherwise compensate the other broker. So in this case interpretation, it says client A calls on Realtor B to list a small commercial property. In stipulating the price at which he wished to list the property, client A explained that he was aware that it was a relatively low price, but he wanted a quick sale, and he added a higher price could benefit very little at that time because of certain tax considerations. He told Realtor B that a number of prospective buyers had spoken to him about the property within the past year. He gave their names to Realtor B and said he felt sure that among them there would be a ready buyer at the price. He told Realtor B that he wanted the property submitted to them first. The next day, Realtor C, who had unsuccessfully solicited the listing and learned that the property was listed exclusively with Realtor B, called Realtor B to ask that he be accepted as a cooperating broker. Realtor B told Realtor C that because of unusual circumstances, the best service to his clients did not require cooperation, that a prospective buyer was at that time seriously considering the property, and that under the circumstances, he preferred not to invite cooperation. Realtor C complained to the Association of Realtors, charging Realtor B with a violation of Article 3 by refusing to cooperate. Pursuant to the complaint, a hearing was scheduled before a hearing panel of the association's Professional Standards Committee. During the hearing, Realtor B outlined fully the circumstances under which the property had been listed by him and maintained that the interests of client A would not be advanced by acceptance of cooperation by Realtor C. Do you think Realtor B is in violation of the Code of Ethics? Okay, I'm seeing a lot of no's, a few yeses. So we have a realtor that successfully got a listing and was told by the seller who to contact. And then we have a realtor who wanted that listing but didn't get it. The seller didn't give it to them, who is now saying that they should have been involved, that they should be allowed to cooperate. So the panel concluded here that Realtor B's reasons for not accepting cooperation in this instance were valid and that his action did not constitute a violation of Article 3. So this was an agent who wanted the listing and didn't get it, and then tried to come in and have the actual listing agent cooperate with them. And when they didn't want to cooperate, they decided to file an ethics complaint. The listing agent's actions did not constitute a violation. Article 4. Remember that Article 4 is about special interest in presenting an offer or in selling a property. You need to make sure that that's disclosed. Okay, client A contacted Realtor B to list a vacant lot. Client A said he had heard that similar lots in the vicinity had sold for about $150,000 and thought he should be able to get a similar price. Realtor B stressed some minor disadvantages in location and grade of the lot and said that the market for vacant lots was sluggish. He suggested listing at a price of $97,500 and the client agreed. In 2 weeks, Realtor B came to client A with an offer at the listed price of $97,500. The client raised some questions about it, pointing out that the offer had come in just 2 weeks after the property had been placed on the market, which could be an indication that the lot was worth closer to $150,000 and $97,500. Realtor B strongly urged him to accept the offer, stating that because of the sluggish market, another offer might not develop for months, and that the offer in hand simply vindicated Realtor B's own judgment as to pricing the lot. Client A finally agreed, and the sale was made to buyer C. 2 months later, client A discovered the lot was no longer owned by buyer C, but had been purchased by buyer D at $165,000. He investigated and found that buyer C was the brother-in-law of Realtor B, and that buyer C had acted on behalf of Realtor B in buying the property for $97,500. Client A outlined the facts in a complaint to the Association of Realtors, charging Realtor B with collusion and betrayal of a client's confidence and interest, and with failing to disclose, you guys aren't even waiting for me to finish, that he was buying the property on his own behalf. At a hearing before a panel of the association's Professional Standards Committee, Realtor B's defense was that in his observation of real estate transactions, there can be two legitimate prices of property: the price that a seller is willing to take in order to liquidate his investment, and the price that a buyer is willing to pay to acquire a property in which he is particularly interested. His position was that he saw no harm in bringing about a transaction to his own advantage, in which the seller received a price that he was willing to take and the buyer paid a price that he was willing to pay. You guys didn't even wait for me to finish. Do you think Realtor B is in violation of the code?
The smile in your voice gave it away.
They weren't even waiting. They were blasting that chat. He didn't disclose anything. And not just that, he encouraged the seller to list at a lower price to take advantage of that. So there's another article that he violated here. If I had to throw another article into the mix, which article would it be? Mm. Silence in the chat. You can tell they're thinking. Someone said 1, someone said 6, maybe 2. I can see a potential to 1 or 2. 2 is tied more to the property itself than which articles honesty. That's 1. Yeah, this is definitely a violation of Articles 1 and 4. All right, so the hearing panel concluded that Realtor B had deceitfully used the guise of rendering professional service to a client and acting as a speculator, that he had been unfaithful to the most basic principles of agency and allegiance to his client's interests, and that he had violated Articles 1 and 4 of the Code of Ethics. I saw it like flash across the screen. I was like, well, what's the cost of that fine going to be? You know, the panels don't always assign fines, right? The panels, they make the decision and they can decide whether or not there should be a fine. But remember, they can fine you up to $15,000. And although they are exercising progressive discipline, so they're looking at how many violations that person has, they're also looking at the severity of the situation. So, you know, they've got to look at all aspects of this. And although it may be the person's first offense, if it's something, again, particularly egregious along these lines, because this is basically a violation of public trust almost, right? They can go ahead and they can decide that the fine should, there should be a fine and it should be X amount. So you guys are going for like the severe. You guys are not having it. Well, good to know, because that means that none of you would ever contemplate this or tolerate it. We have very strong feelings about it. Remember, we can't. Okay, so someone said jail time. We cannot do that, right? But you have all those resources available to you. Yeah, deceit does not sit well with this group. I am happy to hear that. All right, guys. So far, you guys are doing really well. And you're getting a feel for whether or not, like you're getting a feel for how the articles look in the real world, right? It's a nice little frame of reference. All right, Article 6, you're not accepting commission, rebate, or profit on expenditures made for your customer without the client's knowledge and consent. No hidden fees. All right. Realtor A, property manager, bought at wholesale prices janitorial supplies used in cleaning and maintenance of an office building which he managed for his client. In his statements to owner B, he billed these supplies at retail prices. Realtor A's practice came to the attention of owner B, who filed a complaint with the local association of realtors, charging Realtor A with unethical conduct in violation of Article 6 of the Code of Ethics. In questioning during the hearing called by the association's Professional Standards Committee, Realtor A's defense was that the prices at which he billed these supplies to his client were no higher than the prices which owner B had been paying prior to putting the property under Realtor A's management. It was clearly established that no disclosure of this profit or supplies used in property management had been made, and also that in proposing the management contract, Realtor A had held for owner B the inducement of attainable operation. Do you think that this realtor is in violation of the Code of Ethics? So they bought cleaning supplies for their property management business at wholesale prices and charged their customer retail prices without disclosing. The chat is flashing so quickly I can't even see your names. I just see the stream of responses. Yeah, the main thing here is the disclosure. Did they let their customer know that that's how they were going to be billed? And they did not. So this is a violation of Article 6. They gained a profit that they didn't disclose to their customer was built into the agreement. All right, Article 11. This is about sticking to what you know, right? Conforming to what you are reasonably competent in practicing. And if you are not reasonably competent, bringing in resources and people who are and letting your customer know that. Realtor A sold a light industrial property to buyer B, a laundry operator. Several months later, buyer B engaged Realtor A's services to appraise the property and to supply an appraisal report for use in possible merger with another laundry. Realtor A carried out this appraisal assignment and submitted his report. Buyer, now client B, was dissatisfied with the report, feeling that the valuation in comparison with the market price that he had paid was excessively low. Client B then engaged an appraiser specializing in industrial property, and after receiving the second appraisal report, filed a complaint with the Board of Realtors, charging Realtor A with incompetent and unprofessional service as an appraiser. At the hearing, questioning established that Realtor A could cite no other industrial property appraisal he had made, and that his appraisal experience had been limited exclusively to residential property. The hearing also established that when the client proposed the appraisal, Realtor A had readily accepted the assignment and that he had at no time disclosed the extent and limitations of this appraisal experience with his client. Do you think that Realtor B is in violation of the code? As a realtor, you can complete comparative market analysis. As an appraiser, you can complete appraisal. Okay. All right. So Realtor A was found by the hearing panel to be in violation of Article 11. You can offer a comparative market analysis, which is not an appraisal. Okay? Not an appraisal. If you are an appraiser, then you are licensed to provide appraisals. Valuations, that is correct. Okay, so a comparative market analysis is a valuation, it's not an appraisal. The issue is that they provided an appraisal without disclosing that they were not an appraiser and that they weren't reasonably competent to provide information on that type of property. All right. Article 12, that is about being truthful in your communications, displaying that it's a realtor that's sending it, making sure that everyone knows it's coming from a realtor, that it's up to date, that it is accurate. Okay, so prospect A observed a sign on a vacant lot that read for sale, call 330-5215. Thinking he would be dealing with a for sale by owner, he called the number on the sign. He was surprised that the lot was exclusively listed by Realtor A, and the telephone number on the sign was the home number of Realtor B in Realtor A's office. Prospect A filed a complaint against Realtor A and Realtor B, alleging a violation of Article 12 of the Code of Ethics. At the hearing, Realtor A stated that he permitted Realtor B to put up the sign. Realtor B's defense was that the sign was not a formal advertisement, such as an online advertisement, business card, or billboard, to which he understood Article 12 to apply. Do you think Realtor A or B is in violation of the Code of Ethics? Seeing those yeses fly by the screen. All right, guys, good. You are right. The hearing panel determined that the sign was an advertisement within the meaning of Article 12, that its use violated that article of the code, and that both Realtor A and Realtor B were in violation of Article 12. Okay, Article 16. This is my last case interpretation before we move on to some other things like pathways to professionalism. So, Article 16, realtors shall not engage in any practice or take any action inconsistent with exclusive representation and exclusive brokerage relationship agreements. Keyword being exclusive, right? Exclusive representation, exclusive brokerage relationship agreement. At the conclusion of a detailed listing presentation, Realtor B asked the sellers whether they had any questions. No, said seller Z, your presentation was professional and complete, and we very much appreciate your time. We have appointments with 2 other firms, and after we talk to them, we'll make our decision. Realtor B thanked the sellers and encouraged them to contact him with any questions they might have. I really look forward to being your broker, he added. Several days later, Realtor B noticed that seller Z's property had come on the market listed with Realtor A. Realtor B and Realtor A were friends. but were also quite competitive, both frequently pursuing the same potential seller client. I wonder why seller Z decided to list with Realtor A, mused Realtor B. It won't matter if I just call and ask why they decided to list with my friend, Realtor A, instead of me. Realtor B called the sellers and left a message on their voicemail asking for a return call at their convenience. Sorry, guys, my mouse. There we go. That evening, seller Z returned Realtor B's phone call. Realtor B started the conversation by thanking seller Z and his wife for their time. What I'd like to know is why you chose to give your listing to Realtor A instead of me. He then asked, don't get me wrong, he is a good broker. I will do a good job for you. I'm not suggesting you cancel your listing with Realtor A, but if your listing expires and Realtor A hasn't sold it, I'd be pleased to talk to you about listing with me. Seller Z did not follow up on Realtor B's offer, and the following weekend at Realtor A's open house, Seller Z and his wife recounted Realtor B's follow-up phone call. Over the next few days, Realtor A debated filing an ethics complaint. He weighed his friendship with Realtor B against what he saw as his duty to bring potentially unethical conduct to the attention of the Association of Realtors. Somewhat reluctantly, he filed an ethics complaint alleging a violation of Article 16, as interpreted by Standard of Practice 1613. At the hearing, Realtor A called Seller Z as a witness. Seller Z faithfully recounted the substance of Realtor B's conversation with Seller Z and his wife, commenting that while Realtor B had said he was only trying to understand why he hadn't been given the listing, it appeared to Seller Z that Realtor B wanted Seller Z to cancel his listing with Realtor A. Then Realtor B testified in his own defense. He acknowledged he had been aware that Realtor A had already exclusively listed the property when he contacted Seller Z and asked for a follow-up appointment. He defended his actions, stating he was not trying to induce Seller Z to cancel the listing. He was simply trying to find out what he had said or failed to say that led Seller Z to list with Realtor A instead of with him, and wanted Seller Z and his wife to be fully aware of the services he would provide if their listing with Realtor A expired. So, do we think this is a violation of the Code of Ethics? I'm going to tell you right now that generally what happens with this is half of you, well, let's say a third of you will think it's a violation, a third of you will think it's not, and a third of you will be on the fence and say, I really don't know. Okay? So if you're conflicted, it's normal. Usually this kind of brings up a few discussions. So what I tend to hear when we cover this case interpretation in person, I usually ask a few people to volunteer their rationale. And what I hear is, for those that do not think this is a violation, they do not think it's a violation generally because the realtor was simply asking for feedback. And so it's very normal to want feedback on your performance so that you can better yourself professionally. The other side of it is, when people say this is a violation, their explanation generally is, well, then they could have spoken to their friend, especially since they're friends, to see if they could talk to the customers. Or they could have just waited for the listing to expire because they knew it was listed. For people who are kind of in the middle and on the fence, it's generally because you see both sides of the coin and you can argue both sides of it. But in terms of the Code of Ethics, they mentioned Standard of Practice 1613. And Standard of Practice 1613 says that all dealings concerning property exclusively listed, which this property was, and the realtor admitted they knew it was already listed, or with buyer tenants who are subject to an exclusive agreement, shall be carried on with the client's representative or broker and not with the client, except with the consent of the client's representative or broker, or except where such dealings are initiated by the client. So that being said, do we feel that this is a violation of the Code of Ethics or not? And for those of you that were maybe on the fence, does that help you kind of come to a conclusion? So now the answers are yes. And so what I like about this case interpretation is, A, case interpretations help you understand the article in like a real world sense. B, the standards of practice, right? So this is a prime example of how a standard of practice lends some clarity to the article so that you could really understand. So in this situation, given the article and the standard of practice, this is definitely a violation. It's not what he was asking, it's how he went about asking for it. Because it's very natural to want feedback, it's very natural to want to improve, but given the circumstances, how he went about gathering that information needed to have been very specific. So the hearing panel did not agree with Realtor B's defense, noting that Realtor B's curiosity or desire to enhance his listing presentation skills did not justify continued contact with a potential seller client after that seller had entered into an exclusive representation agreement with another broker. Realtor B was found in violation of Article 16 as interpreted by Standard of Practice 1613. And again, these case interpretations are great. They've got a ton of them on their website, organized by article and standard of practice. Definitely check them out, especially if you find yourself in a situation where you may want to file something. You can definitely look at the case interpretations beforehand. I've had situations where people describe what happened and it is almost identical to an already existing case interpretation. So you can check those out. They're definitely a great resource. Before we jump into part 6, which is our last part of the presentation, which is pathways to professionalism and marketing that code of ethics, let's go ahead and take it's going to be a little bit more than 5 minutes, but let's go ahead and take a break until 1:05 and come back, and then we'll wrap up the presentation with part 6, which is pathways to professionalism. So let's take a break till 1:05. All right. So we are coming back for the final stretch. We are almost done. We're going to talk about pathways to professionalism and how to use the code of ethics in your day-to-day life. So knowing about the code of ethics and being aware of what it requires of you as a realtor gives you a competitive advantage over agents who may not be as aware or who may not be as to date on it, right? Which is, again, why I recommend keep up with it, look at it every year, see what's changing, what's coming. It guarantees that your customers are getting the best from you, that they know what to expect of you and any other agent that they encounter while they are in a transaction or moving forward. And then you can use it to train new agents. So as you move forward in your career, maybe you decide to build a team, to become a broker and start your own brokerage. You can make sure that you're starting your agents off on the right foot by getting them trained up on the code of ethics. And of course, it's going to be a reminder continuously that these are the services you provide and how they should be provided. Okay, so you can use it to model your behavior and to determine who you would like to work with moving forward and how to work with others moving forward. You can also use it as a part of your marketing. So when you are talking to a customer, they do have it available in 15 different languages. So you can go ahead and have copies of it in your customer's preferred language. So you can market with it in your listing presentations, etc., or in any of your presentations with potential customers. It's going to let your customers know what to expect of you, what to expect of other agents they may encounter. You're going to get a pin. Since we are virtual, you can get a pin at any of our office locations. You just walk in and ask for one, and they'll go ahead and give it to you. Or next time you take a class, just stop by the concierge and ask them for your pin. Okay. And just some tips for professionalism. So follow the golden rule, treat other people the way you want to be treated. Be courteous and respectful, obviously. Make sure you're communicating in a timely fashion. Someone said there's no sound. Let me double check. I'm showing as connected. Okay. Thank you for confirming that, everyone. So show courtesy and respect, communicate in a timely fashion. Make sure you're always presenting yourself professionally. I would talk to your broker. Some brokerages have like shirts and, specific colors they might want you to wear. And I would talk to your broker and ask them what they would want you to wear or how they would like you to present yourself when you are working with customers or going to the office. Be aware of your deadlines, obviously. Be aware of the respectful cultural differences. Okay. What might seem really innocent to one culture might be indirectly offensive to another. You don't intend to, but just be aware of the cultural differences, especially in Florida, where we have such a huge global market. And then one other thing that I want to point out with this slide is be very clear with your customers about what communication looks like and make sure that you understand really prefer their communication. So, do they want you to email? Do they want you to call? Do they prefer text messages? Let them know. Yeah, I might be in a meeting, so it'll usually take me this much time to get back to you. If you email me, I usually get to you in this time. When you do that, it helps a lot of the frustration that comes from, quote unquote, lack of communication. If they understand that your communication time looks a certain way, right? So you're going to make sure that you communicate that ahead of time and that you know how they prefer communication as well. Okay. So we're going to move on to pathways to professionalism, which is respect for property, respect for your peers, and respect for the public. As far as respect for property, when you are showing a property, make sure that you are responsible for your customers and that you're keeping them together. So if you have a group of them together, don't let them wander off on their own, because whatever happens while you are there is your responsibility. That is on you. Make sure that you have made accommodations to provide access to listed properties. If you are the listing agent, make sure you are very clear about showing instructions and when the property is available to show and that you make the correct accommodations. Some people are complaining about sound. Nothing has changed on my end. I'm still connected the same way I was at the beginning. Some of you are having issues, some of you are not.
It sounds great from my end too, Maggie.
Okay. So back to the respect for property. Make sure that you make accommodations to grant that access, that you're very clear about the access. Leave the property as you found it. So if everything was turned off, you turn it on. Make sure you turn it back off before you leave. Make sure you're considerate of the seller's property. People shouldn't be eating, drinking, smoking, or trying to get rid of trash while they're there. They shouldn't be bringing their pets. If they need to remove their shoes, like make sure you know all of that first. And as a listing agent, make sure that those going to view the property know that as well, so that everyone can have a successful showing. But just be really mindful of the property and the fact that at the moment it belongs to someone else still, and we want to respect that. So before taking any sort of photos or recording anything or streaming anything, make sure that you have permission to do so from the listing agent and or broker. Just because some people, it might be a privacy issue. It might just be that they're not comfortable with it. Just make sure that you've talked it out before you go around snapping, photos and videos. Okay, respect for the public. Follow the golden rule. We've talked about this a few times. Treat other people the way you would like to be treated. Okay? Even if they're not doing it. Maybe you'll inspire them to do it, right? But let's make sure we're treating other people the way we want to be treated. If you are receiving phone calls and text messages and inquiries, make sure that you are answering promptly. Make sure that you're scheduling your appointments as far in advance as possible. If you are running late, if you need to cancel an appointment, if you need to reschedule, if, your customer changes their mind, make sure that you tell the listing agent, because some of them are there waiting for you, and they are available during the showing. And so it's their time as well. And just, they deserve to know that you're either running late or can't make it and need to reschedule, or your buyer or your customer changed their mind. Never criticize the property in the presence of the occupant. And I always say with this one, let's just cut it off and say, never criticize the property while you are there, while you are present. A lot of people have cameras. The other agent might be there. And so it would be best to just get that feedback from your customer once you have left the property, right before you go to the next one. Have them take notes and then discuss those at the end, right? Because you don't want to disrespect anyone. You don't want to upset anyone. And people have their opinions. Everyone has different, tastes, and they have different preferences. And so whatever your customer may think of the property, have them take some notes and then you guys can discuss it at the end of the day. When you are showing a home and it is occupied, right? And you know it's occupied, knock on the door. Don't just go in. Make sure you announce yourself. If there's a door that's closed, knock on it before you open it because you don't know, it's occupied. You don't know who's where, and there might be someone behind that door. Make sure again that you're presenting yourself professionally. Talk to your broker about what that looks like for them. If occupants are home, ask for their permission before going to the restroom, right? Make sure that if someone comes up to you and says, oh, I have an agent, but they're not talking to me and they're not answering me and they're not answering my questions and whatnot, redirect them back to their agent. And if their agent, if that's not working, redirect them to the broker of that agent. And if that's not working, tell them to come talk to professional standards. Okay? Because we can step in with something like an ombudsman. Communicate clearly. Make sure you're using terms that are understood by everyone, right? That you're not using like lingo and abbreviations and acronyms that maybe not everyone knows. Make sure that you're respecting those cultural deadlines, that you're those differences, that you're respecting deadlines, that you can deliver what you're promising, right? We don't want to make empty promises. And don't tell people what you think, tell them what you know. So if a customer asks like, oh, is this a safe neighborhood? Is the school in the area good? You can refer them to resources that they can use to determine that for themselves, but we are not going to tell them what we think. We are going to tell them what we know. And what we know is here's this website where you can do some more research. Here's this report that gives you information on schools. I talk about it every time. RPR has a school report. You give it a property address and a radius, and it gives you all the public, charter, and private schools within that radius and any reviews that they could have gathered from resources like Good Schools. So you give them the tools and allow them to formulate their own opinions. Do not share your opinions. Do not tell them what you think. Okay, it could inadvertently become like a fair housing issue, and they might have a different experience than you did. So, let's just allow them to come to their own conclusions. So there are some questions that came up about that. Can you say the neighborhood has top rated schools? I would allow them to just figure it out. The Herald always publishes it in Dade County. The Sun Sentinel publishes it in Broward. Miami-Dade County Public Schools has a rating, the list of their schools, the ratings. Same with Broward County Public Schools. Every major school district does. I would just allow them to determine that, because what you consider a top rated school, is it the school grade? Is it the graduation rate? What is it? So allow them to research and determine what would be best for their family and their children. The school report on RPR, and the RPR reports are shareable, and you can create them and share them from your phone too. And there's Connie with all the rest of the resources. Thank you, Connie. Respect for your peers. So respond to your fellow realtors promptly. Don't leave them hanging. No one likes it when it's done to them. Don't do it to others. Contact the listing broker if something seems off with the MLS data, or you can use that caution symbol that we talked about and you can report it yourself. And that's anonymous, and that's through the MLS. If you are the listing agent and you are giving others access, make sure that they have all of the information that they need to have a successful showing. Is there a guard gate? Is there a keypad code? Will the owners be home or not? Are there, going to be pets present? Is there an alarm on the property? All of that. You want to make sure that they have everything they need so that they can show the property without encountering any issues. Inform them if the sellers are going to be there. Inform them if you're going to be there as the listing agent. Make sure that you're being courteous and respectful to each other. Be nice to each other, please. Don't use endearments. You could mean it very nicely, very sweetly, but to someone else that could be very disrespectful. We don't want to do that. Don't prospect at other people's open houses. You're not there to look for customers. You're there to look at the property. Okay? If there is a lockbox, make sure you have an appointment. Just because there's a lockbox on the door does not mean that you should access it with your super e-key. Make sure that you have permission to do so, because you don't know who's home. If they do or don't know that you're going in there, it's a safety issue. We're not going to do that. Okay? It's also potentially unethical to access a property on terms other than those set forth by the listing agent and the owner seller. Okay? So we want to make sure that we're following the rules, that we're following the procedures, that we're going through the appropriate avenues. The other thing, if you access the keys from the lockbox, you need to make sure that you return the keys to where you found them. If someone else is coming up and they're going to show the property next, do not hand them the keys, because on that lockbox, it shows you as the last person to access. And so if anything goes left, if anything happens, you're the last person on record to have access to the property. So return the keys to the lockbox and allow the other person to use their e-key to open that lockbox. You want to be nice? Help them use their e-key if they don't know how. But make sure that that super lockbox has clocked when you accessed it and when you returned it, and then let the next person access the lock. And then last but not least, although we are the largest local association, we have 60,000 plus members, it is a very small world and everyone knows everyone, especially in real estate. This is a reputation-based business, and something that you do today might affect what you encounter tomorrow. And that could follow you for a long time. So make sure that you are, again, always trying your hardest to treat other people the way that you want to be treated, to step into these situations with kindness, with, being respectful, with being courteous, because we live in this huge, metropolis, right, in South Florida, but somehow everyone's connected. And sometimes it's even less than 6 degrees of separation. And in real estate, it's even fewer. So make sure that you are always approaching things with your best foot forward. Okay. And that's for my portion. Before you leave, we are going to do the realtor pledge. Connie, if you want to jump in and walk them through.
Are we ready?
And we are ready. Remember, if you need me, you can reach me at professionalstandards@miamire.com. All right, and I'm going to hand it off to Connie for your realtor pledge.
Give me a second. I was doing something. I'm sorry.
All right, guys. In the meantime, if you need to stand up and stretch, go ahead and stretch before Connie has you take your pledge. Remember, you can get your pins at any of our offices. We have an office in Coral Gables, in Miami Springs, in Hialeah, Aventura, Sunrise, Fort Lauderdale, Hollywood, and Jupiter. I don't think I missed
Oh, you put it on screen. I was looking. I didn't see you switch it.
I already put up for you. I am prepared. All of our offices are open Monday through Friday, 9 to 5. Please keep in mind that next week for 4th of July, we are closed on Thursday and Friday for the but our offices are open 9 to 5, Monday through Friday regularly. Okay?
Are you guys ready? Raise your right hands and say it. I am a realtor. I pledge myself to strive to be honorable and to abide by the golden rule, to strive to serve well my community and through it my country, to abide by the realtor's code of ethics, and to strive to conform my conduct to its aspirational ideals, to act honestly in all real estate dealings, to protect the individual right of real estate ownership, and to widen the opportunity to enjoy it, to seek better to represent my clients by building my knowledge and competence. Alrighty, congratulations to everyone. Thank you so much for having joined us. Thank you, Maggie, for your time. Thank you to all of you for being Miami members, and we hope to see you in a class at our events and join us here at our new global headquarters. Have a great day and take care. Signing off and wishing everybody a whole bunch of luck. Bye-bye.
Congratulations, everyone. Bye.
Congratulations. Bye.